Today I'm happy to announce that the United States Justice Department has intervened in a major whistleblower case involving HCR ManorCare. HCR ManorCare is one of the largest providers of nursing home care in the United States. Some 280 SNFs, or skilled nursing facilities, are operated by this particular company. In January of 2009, Ms. Ribik, a relator who was also an occupational therapist, filed her initial complaint against ManorCare, alleging Medicare fraud in the provision of skilled therapy services. The complaint alleges that ManorCare was involved in a systematic scheme to upcode skilled therapy services. When a patient goes into a skilled nursing home, he or she may be eligible for skilled therapy services. Those services, under the prospective payment system, are billed in different categories, from low, which is a low reimbursement category, to medium, to high, to very high, to ultra high. It's only in the ultra high categories where the nursing homes receive their highest level of reimbursement. And the allegations in this case claim that ManorCare, through its rehab directors, would push most patients into the very high and ultra high categories, even when their medical condition did not justify such extensive treatment. The ManorCare case is very similar to a case that the Justice Department intervened in involving Life Care Centers of America that's currently venued in Tennessee. Almost identical allegations of upcoding were involved in that case, where the government sought to prove significant damages through a statistical damage model. The defense in that case attempted to challenge the government's use of a statistical damage model, and those objections to that type of damage model were overruled in the Life Care case. And it would be reasonable to expect the government to rely on a similar type of damage model in proving this case. The government should be commended on their investigation that they've done in this case. As you can tell by a reading of the government's complaint, they've uncovered some very damaging facts that establish the fraud, at least at the pleading stage of this case, very persuasively. And I would encourage you to review the government's complaint, which is attached to my website. The whistleblowers who come forward in these types of cases should be commended for their bravery in willing to put their name on a complaint in an industry where fraud, unfortunately, is commonplace. But keep in mind that it is only through whistleblowers like Ms. Ribik that the government is ever going to be made aware of this type of fraud, as Medicare doesn't have internal audit procedures often, or at least not enough procedures built in to catch fraud at its early stages. As such, the government relies upon whistleblowers to come forward to report this type of Medicare fraud. Whistleblowers that come forward and report a case that ends up being a successful prosecution are eligible to receive anywhere between 15 and 25% of the government's total civil settlement. If you have knowledge of fraud or information related to the allegations in the ManorCare case, I would suggest that you should come forward, either call my office or call the U.S. Attorney's Office with information, as it's important that the government continue in their investigative efforts as this case goes into discovery. I thank you for your time and attention, and I look forward to hearing from you.